If you get hurt on a rented boat, can you sue the rental company too?
Yes, oftentimes you can sue the boat rental company. This particularly comes up in cases where the boat, for instance, was rented to someone and it wasn't properly maintained and that caused an injury. Or perhaps the boat was rented to someone who was obviously intoxicated at the time it was rented to them. But there are a variety of situations in which case a boat rental company can be liable for someone's injury.
If your friend was driving their boat and you got hurt, does insurance cover you?
Who's at fault if you're injured while on a friend's boat? Well, the driver of the boat can oftentimes be responsible, especially if they were behaving in a negligent way. And the boat operator's insurance oftentimes will take responsibility and cover the damages caused by that negligence.
If your boat hits a swimmer near shore, who's usually at fault?
If a boat hits a swimmer near shore, oftentimes the boat operator is at fault, especially if it's an area where individuals are known to swim or where that type of recreational activity often occurs. It is the boat operator's duty to operate the boat safely and to keep an eye out for hazards and other individuals who could be harmed by the boat.
If you were tubing and the driver makes a sharp turn, is that negligence?
A sharp turn by a boat driver pulling someone on a tube could certainly be negligent, especially if the speed of the boat is high enough and the turn sharp enough that it causes an injury to someone riding on the tube, and especially if it is done without warning or in a way that the tube rider would not expect.
If a boat ramp accident happens while launching, who is liable?
There can be a variety of individuals or companies liable when somebody is hurt on a boat ramp. It could potentially be the owner of the boat ramp if the ramp was not properly maintained or had an unreasonably dangerous condition on it. Similarly, it could be the individual who was unloading the boat or who was backing up the trailer if that caused the injury and the person conducting that activity was not careful and engaged in that activity in a negligent manner.
If a child drowns in an apartment pool, what safety failures matter most?
Child drowning in apartment pools are tragic, but unfortunately they happen almost every year in Texas. The most common safety failures that we see in these types of cases are lack of adequate fencing, missing locks that allow children access to the pool when they should not be able to, also drains that are not properly covered, or other hazards in the pool that could cause a child to be trapped underwater.
If the pool gate does not latch, is that enough for liability?
Pool gate that doesn't latch at an apartment complex or other public pool can certainly be the basis for liability in a drowning case, largely dependent on the age of the child. If it's a young child who should not have been able to gain access to the pool, if the latch should properly function, that can certainly be grounds for holding the owner of the pool liable for a death or injury that occurred in the pool.
If there's no lifeguard, does that automatically mean someone is at fault?
The lack of a lifeguard does not necessarily mean that a pool owner is at fault. The circumstances surrounding each pool injury or drowning are unique, which is why you need an experienced personal injury lawyer to help guide you through the facts of your situation and to advise you about whether you have a viable claim.
If a drowning happens at a friend's pool party, can the homeowner be liable?
If a drowning or other pool-related injury occurs at a child's birthday at a friend's home, the owner of that home can potentially be liable based on several different types of theories of negligence, especially if there was a problem with the pool or it was not properly maintained, or if whoever was throwing the party had let the parent of the injured party know that they would be say, watching the children to make sure they were safe and were in fact not doing so.
If alcohol is present at the pool party, how does that affect the case?
Alcohol can have a huge impact on cases involving injuries at a pool. It can be a cause of liability for showing that the responsible party who should have been, say, supervising the child was intoxicated instead of being diligent and making sure the children in the pool were safe. Conversely, insurance companies, if an adult is injured, may often try and shift the blame for that injury to the injured individual if that individual has had alcoholic beverage. But the fact that an injured individual had an alcoholic beverage or two does not mean that they do not have a claim.
If a water park ride operator sends someone too early and there's a collision, who's liable?
So in the event of a collision between two individuals who are trying to enjoy a ride at a water park, and it's caused because the operator of the water park ride sent the second individual too early, the water park itself, along with the operator, may be held liable for any injuries to either of the riders caused by that ride operator's negligence in sending the second rider too early.
If a dock board breaks and you fall, who's responsible?
If you're injured because a board on a dock breaks, the owner of that dock potentially is liable for the damages and injuries you sustain, especially if the board was already known to be broken, or if the condition of the dock showed that the boards were old and in need of replacement, and something that an ordinary and a prudent dock owner would replace or maintain. Should be noted, there are also potential other parties that could be responsible. Say, if a business has leased the dock from the property owner and the business that leased the dock was supposed to maintain it, then it would be the business that leased the dock that would likely be the responsible party.
If a rental says use at your own risk, does that stop a claim?
No, a simple disclaimer from a rental company that says use at your own risk, say for a jet ski or a boat, does not necessarily prevent an injured party from pursuing a claim. That's especially true in situations where the equipment that was provided does not operate or function properly, or has unique characteristics that a normal individual renting that type of equipment would not be expecting.